right, good morning. Welcome to the Thurston County Board of County Commissioners Board Work Session for Monday, March 4th, 2024. It's 10:10 a.m. My name is Ty Menser, Chair of the Board. Our Vice Chair, Commissioner Fournier, is excused this morning. We have Commissioner Klaus, Commissioner Mejia, and Commissioner Edwards. For public virtual attendance, you may follow along on Thurston County YouTube channel. We are here, if necessary, until 12, although we don't anticipate needing that much time. I will need to excuse myself just before 11 if we're still in session. First topic up is board legal representation. We have our prosecuting attorney, John Tunheim, kind of a follow-up to an email that I had sent, and I guess I can kind of frame where we're at on this particular topic. We've had discussions amongst the board about when prosecuting attorney plugs into board meetings and what, when and how, and Commissioner Edwards has been an advocate for more. And then Commissioner Mejia made kind of a suggestion, since we have a more slightly compressed new schedule with fewer Tuesday meetings. Commissioner Mejia made a suggestion that maybe a compromise between where we were and where Commissioner Edwards has advocated for us to be would be to attend those two per month. Sometimes there's three, it's first, third, or fifth. So I was asked as the chair just to reach out to prosecutor and just see, how that idea sat, and he had some questions back. So I thought we should just have a discussion about it instead of me being the middleman and playing telephone between the board and the prosecuting attorney's office. So here we are to kind of just talk through what the pros and cons would be and concerns, and so that's kind of the setup. And I don't know, John, maybe if you wanted to restate kind of the questions that you had for me in your email, and we could go from there.
Sure, assuming I can remember them.
Yeah.
But because I was kind of, it was, the context was helpful of the email, but maybe I'll just start off with some general thoughts, because my understanding, this is kind of a long-standing conversation in, it kind of ebbs and flows. And what we're trying to do, obviously, is find a way that we can be responsive to what the board needs in terms of the legal, issues that come up from time to time while you're working through issues. But at the same time, allows my lawyers to be as efficient as possible with their time. And one of the things we were running into as I was talking to Elizabeth about transitioning this responsibility to Travis and so forth, she was very clear with me that we needed to be very cautious about how much time we could promise to the board in terms of just like meetings where there's not a specific issue that we're anticipating coming out, because early on she felt like she was spending a lot of time sitting in meetings with the board where there was really nothing relevant for her to do, right? Of course, it can be helpful to get context of things and so forth, but it was consuming a lot of her time with very little productivity. And as you know, all of my lawyers, my civil division, have multiple clients, and so they're constantly, working on things with not just the board, but with all the other clients. So she was encouraging me to be very cautious, and that's one of the reasons that I made some of the, tried to put together some boundaries, if you will, in that initial presentation that I gave. That being said, I want to be responsive to the board's needs as well. So I thought that was the gist of the questions that I had when Commissioner Menser sent me the email was, let's figure out if there is a way, one, that we could maybe identify specific meetings where it is more likely that you would need some type of input from an attorney during the meeting. And or meetings where we specifically know that there will be a possibility for legal input, and see if we could figure that out. And then of course I can ask Travis to make himself available for that, but without having to make it such that he comes and sits through a 2-hour meeting and there's not a legal issue in sight, and basically he's just sitting here with a couple of hours of non-productivity, feeling stressed out because he's not doing the other things that he needs to be doing for the other clients. So that's the balance I was trying to strike. So my question is, like, what's the best how do we identify meetings ahead of time? What's the specific purpose or goal of the board in terms of having a lawyer present at that meeting? And how can we make, the most efficient use of both the board's time, but also Travis's time, or whatever lawyer is working with the board on a specific issue? That was the gist of it. There may have been a few more specific questions in that email, but that's kind of where I was approaching it. And I love the idea of having this meeting so we can kind of talk openly about what solutions might be out there.
Commissioner Mejia.
So thank you for those questions. And I've been really thinking on the questions that you had sent via email, and kind of trying, to come up with a response that was kind of portrayed what our needs were as well. And so my suggestion with the 2 p.m. meetings was because the meeting times have been reduced so significantly. It's usually where we get, we're only having 2 a month now.
2 to 3.
2 to 3 a month. And those usually are shorter, just because by that point we have gone through the process. However, there's been several instances where there have been questions from the public that I would feel would be not for Travis, to put Travis on the spot to answer it, but just to be like, Travis, can you check up on this, and then, we can have a discussion at a later date. I'm not expecting Travis to, my expectation would not for him to be sitting right over here. Maybe I know that sometimes we get 0 public comment, but maybe via Zoom. And if there is a question, for us to have just that availability with our attorney and start building that relationship as well, even more. So that was kind of one aspect of it. And another aspect of it, I guess, is the procedural questions in terms of Robert's rules. Oh, do we need to reapprove this, or are we okay to move forward with this, right? Sometimes, I know both me and Commissioner Messer have taken, and I'm sure other commissioners have as well, Robert's rules classes, but sometimes questions in terms of procedural, do we need to reapprove this, or do we need to just having an attorney that maybe we can ask those questions from might be useful for the board. And so that's why I thought the 2 p.m. meeting, since it is a public meeting, right? It is, I think, one of the meetings that usually the public views the most, they have the most interest in. I thought that could be a good middle alternative where we could have an attorney present for those, and not with the expectation that we would be putting any of your attorneys on the spot. I think the board needs to understand and acknowledge that, whatever question we ask is not going to be answered right there on the spot, but there's going to be, it's going to come back later on.
Yeah.
I'll get to Commissioner Edwards in 1 second, because I just want to piggyback on Commissioner Mejia. I would love to be like Hunter S. Thompson and have my lawyer walking around with me everywhere I went, but understanding the realities of the resources, I've never really taken issue with the suggestion that we should have more legal counsel, because that's always good, right? It's not a bad thing from just our selfish perspective as a board, never having sat down with you to really talk about the resources. But I'm very respectful of and sensitive to your lawyers doing, being most efficient with the huge burdens that they take on for the different clients. So I wouldn't even really even be advocating for this myself, but for the fact, as Commissioner Mejia, she kind of piqued my interest with the idea of like, well, with, if we're down to 2 meetings a month, and they last about an hour and a half, and those are the formal, I'm trying to make the case a little bit, like, for that more reduced, request, that's where we take formal business, It's really important that process is right, that, if an OPMA meeting issue comes up, or a legislative, like, propriety issue like that, and so I think things do come up, every month or two, where there's something like that really we'd all feel comfortable. So I don't know, balancing, the time commitment versus the criticality of the decision-making and the guidance that we need in those formal business meetings felt like and now with only, 2 to 3 versus 3 to 4, it felt like maybe we were getting in the zone where that was a proper trade-off. I'm not sure, but, but that's kind of what I was thinking about as I was like, trying to balance all the different considerations. Commissioner Edwards, go for it.
Okay. I don't disagree with anything that my seatmates have said, really. I've been advocating for this for years, and now I think it's ever more important because we really live in a world where nobody answers the phone anymore. You call any government entity, and I mean, I'm not saying it doesn't happen, but boy, you get a lot of voicemail. And then there's a lot of the text activity. So I think from my perspective, the most important meeting might be our agenda setting, because at our business meeting, we end up having things pretty well worked out by the time we get to that point. But at our agenda setting, and I'm just going to use the most recent land sale issue with the treasurer as an example, where we have questions about what is the process, what is legal, how that all fits together, I guess. And then, I mean, the reality is that in some of these, the prosecutor that would be in attendance, and I don't know that they need to sit in the meetings as much as maybe Zoom in, but at least be there, they pick up a flavor for what's going on. And I really think that in the past, when there was only 3 of us, we were never able to discuss anything outside of any public meeting. And that allowed basically staff to end up running the show to some degree. And we'd get answers from the county manager maybe during a agenda setting. Well, I've talked to so-and-so, or I think this is okay to do this or that. I don't think that gives us the proper coverage that we ought to get as a board, whether that's some political coverage, if you will, or legal coverage. And I don't know to what extent we end up with legal coverage, but I can tell you that citizens that hear somebody from the legal end of things say, well, I'm not sure that's right according to Open Public Meetings Act, or I think it's okay under Open Public Meetings. It gives us something. And so I just think a terrible answer is, I don't know. And then we have to send somebody a text or an email to try and get an answer because the phone doesn't get picked up. And I just think it'll make us so much more efficient and give us better answers in a timely fashion. And it isn't all the time that we need it. That's true. But whomever could review the agenda and maybe give the prosecutor's office a heads up that, well, we've got kind of a ticklish issue here on a topic. Maybe you could attend agenda setting. But as a general rule, if I had to pick one over the other, I believe I'd pick probably agenda setting and sometimes our work sessions where we're actually talking about different issues that might come up. At least be available for that phone call if you're not there to listen in on the meeting or be in attendance. But I just think a personal attendance is worth something. Anything short of that is is maybe not quite as good, but still I think it's beneficial. So those are kind of my broad thoughts on the topic, and I'll let somebody else get in there.
Commissioner, if I can, I think it boils down to a lot of the questions come up. It gets back to procedural questions of sort of what's the process, how it should unfold. Because when you think of the lion's share of the items that come before the board on the Tuesday meeting, they've already gone through some type of, the contracts and et cetera have already gone through and been signed off by legal counsel. So it's not so much those per se, but it tends to be sort of, well, what's next? And I like the tax title sale, because one of the questions was, so we have an offer, it's on the table, what do we do with it? How do we, if we don't support it or the board does not support it, what's the process? You actually have to kind of have it run its course and take the vote. It's those types of things that pop up, but I also think it's incumbent upon us as staff that we could do a better job of identifying, what are those topics as our work sessions kind of get filled up to kind of know where there might be stickier issues, and maybe make specific invitations to those based on either it's Travis because he's supporting the board, or it's someone else because their client is X, Y, or Z department or office.
Which, if I'm hearing you right, then is maybe more towards Commissioner Edwards' argument that perhaps the work sessions are the more important meetings. Is that?
I think that tends to be where the deeper dive is and questions emerge on agenda items. Tend to be the agenda setting and or, yes, a work session, depending on what's scheduled for that day.
I mean, I don't disagree with that, but that's where we start to get a little more into the inefficiency question, because like certainly the meatier questions where we need more help come up in those meetings, but it's a 3-hour plus meeting, every Tuesday. And, there's going to be Tuesdays where nothing comes up, and it just feels like a wasted half day for one of our lawyers.
Could there be a structural change to the meeting? Again, I'm just throwing out an idea. Could there be a structural change such that if there was something that came up we could maybe arrange to have a lawyer during a certain portion of the agenda?
Why don't we say like 11:30?
So it'd be like a parking lot.
Something
that
comes
you put
up,
stuff?
then we know a lawyer's gonna check in at 11:30 on Tuesday morning, and whatever, we just table. Like if something come up at 9:30, oh, okay, Travis gonna be here at 11:30. We have that standing ability to, then we're only using 5 minutes of their time if nothing came up, half an hour of their time if something did, but they're not waiting all morning to be there. But then we get in a quote unquote immediate. What do you think about that, Commissioner Edwards? Do we tracking that idea?
I think that's fine. Anything is going to be an improvement, is the way I'm looking at this. And if we implement it incrementally, and we can revisit it, at another time. I think it's great if we just make some steps to the positive. That's all. Thank you.
Which would only be the second and fourth, basically, Tuesdays, which are the longer reviews prior to the first and third Tuesday meetings.
So you're suggesting that it would actually be the agenda settings that correspond to the open public meeting, we could have maybe a standing agenda item that is prosecuting attorney's office or something. Or would just be available.
Or that if just Travis was just checking into the Zoom at 11:30, we all know that, and then whatever we've come up with, we could let him go. If I see him check in, I'd be like, you know what, Travis, I don't think we need you today. He's gone 5 minutes later. But then anything that came up, we were able to kind of hash it out with him right there in the context of the same meeting. That feels like a pretty good, that feels more comfortable to me in terms of meeting your needs of efficiency.
Yeah. Well, and then, like you say, it doesn't it also then doesn't create a spotlight for the lawyer at the public meeting, which is another one of my concerns, because I think I've said this in this meeting before, that the answer to every legal question is it depends. You know, and so that's the only answer you're ever going to hear in a public meeting unless the lawyer's been researching it ahead of time. And sometimes that's kind of uncomfortable for a lawyer to sit there and say, well, I really don't know. It kind of depends and I got to look into it. But if there was the ability to work through some of these in that agenda setting, and then that way there's some context things that Commissioner Edwards was referring to too, where the attorney would have the background of the agenda setting meeting to start to be able to really look into the issue rather than have something come up at a public meeting. Now that's not to say, I think if there was an issue that we knew was coming up in public meeting, that it would be helpful to have a lawyer present on. I would open that up. I do want to say very clearly so everybody hears me that I never want anybody to feel like they shouldn't call the lawyer when they really need, and that goes for the board or any other client, because quite frankly, my civil division has always felt very strongly about trying to be proactive than reactive and, you know, deal with issues before the you know what hits the you know what, rather than, you know, try to clean up the mess afterwards. So that's why I very much want to encourage a good open line of communication. When a lawyer is needed, we will have somebody there for sure, or even if it's anticipated. But I think that there might be something here, and I would want to sit down with Travis and Scott and talk it through, but I think there might be a way here that we could clearly have somebody available if it was predictable, you know, when, and that you could kind of parking lot things, and then they could be a little bit more efficient in taking maybe even multiple issues at the same time. Again, as long as the expectation isn't that there might be an answer right there, but it would give us the ability to ask the questions we need to ask and then take it under advisement. And then get back to you, and or suggest that maybe an executive session be necessary if we need to dive into it further. I think that might be something that could be manageable, and I'm willing to talk to my team about that. If that feels,
I think we should
okay
try
to
that.
everybody.
I think that seems like a good thing to try, and I think it would cover, it would, from what I'm hearing, it would be the best balance of the different
yeah.
considerations. And thumbs up from Commissioner Edwards.
Okay, well, as long as I'm kind of with Commissioner Edwards, let's try something. And then if it seems to be working, then great. If there's something that's not working, we come back and we talk again. But I do think that helps strike a little balance where my lawyers aren't feeling like, you know, they got to constantly be sitting in on the meeting. I will say that one of the other things that Commissioner Edwards talked about is that it's helpful for the lawyer to kind of have the context of the conversation. And I would absolutely agree with that. But one of the benefits now of you doing your meetings on YouTube is that if something comes up and the lawyer needs that, they can go back and review that. And we've done that. In fact, Elizabeth remarked to me about that a couple times, where she was really glad that the meetings were out there, where she could go back and really hear the whole conversation. That can be really helpful. So that ability is there now. And so I'm saying that so Commissioner Edwards knows that, you know, we can go back and we can get that context when we need it. And I do think that's valuable without having to try to anticipate, you know, as or guess, if you will, when something might come up. And then I end up having somebody sit through an entire meeting where they really didn't need to be there for any particular reason.
All right, well, let's start with that.
You okay with that?
Yeah, let's
All
start
right,
with that.
I will chat with my team a little bit, and then probably have Travis maybe follow up directly with somebody to nail down exactly how that might work, but I think it might be a good compromise.
Perfect. Commissioner Fournier's with us too, and he thumbs up that.
Okay?
Thank you, John. Appreciate
Okay,
your time.
all right, yeah, absolutely.
Thank you.
All right, next up is just commissioner items. If there's anything we need to address, we do have a session this afternoon, but
Just a heads up, I will be late to the commissioners check-in.
two.
Yeah. But so I want to go ahead and give an update on the Boston Harbor sale. I'm sure that, I don't know if all of you have received the emails, but we've received quite a few. And I know Taylor's gathering them all up and sending them over to the clerk, and those will be sent over to you just in case you haven't seen them. So there's a lot of community concern in regards to that. We did receive an update from the treasurer that the person who had made an offer withdrew their offer. And so that is now taken off our agenda for tomorrow. And so then it will actually be going to auction, and they'll be setting up that sale since the association has demonstrated interest, as well as the person who lives right beside the property as well. So Treasurer Gadman, just in an issue of fairness, he's going to put this property up for auction. However, the association still wants to continue to have that conversation about tax title properties as well as surplus properties, and so we will continue to engage them in that conversation and continue to schedule the meeting with Treasurer Gadman. And from our end, we have let them know that Public Works has no intention on surplusing any of those properties in the near time future. So just.
Commissioner Edwards, I see your hand.
Yes, I think, I'm glad to hear that's where we're going, but I brought up the other day that in the future, when someone approaches the treasurer about a tax title property or some other surplus property, the whole thing about notification sounded like, well, we got all these people, we'd have to send notices out to everybody and all that. I think if we came up with a policy as a board that we would post the property for a 30-day period after the treasurer has had someone contact him with an interest, that I think that would suffice on the public notice end of things. I mean, I don't know, we could run an ad in the paper, I guess, but I just think there's a simple solution to how we proceed in the future.
Okay, yeah, I kind of liked your idea there. I know there's some properties that might not work that well, but it seems like most of the ones that I've been involved with, that would work. And the treasurer would have to sort of have a pattern where on initial contact, he says, okay, before I can accept your offer or enter negotiation, board policy, county policy says we have to do a posting, and then maybe that gets us there. I don't know, but that's something that we can definitely talk about with the treasurer.
Yeah, we might want to talk to a lawyer about that.
Okay, well, 11:30 next Tuesday. So it sounds like we're off the hook, so to speak, in terms of needing to make a decision because there is no offer now to be done. So it's all about policy for the future and this potential auction for the community. All right. Any other commissioner items before we adjourn this morning?
No, I didn't come with the idea we'd be spending too much time on stuff. So we have a meeting this afternoon as well.
We sure do. So we will be we'll adjourn for this morning, back at 2 p.m.